I'm going to take up the motion for business valuation first because it's pretty short and sweet and to the point. Mr. Joseph has run his, I think it's Joseph Tech, for at least the last couple of decades, and he has obviously built up some goodwill and some a marketplace for his business, and they have valued it for just the physical assets, and they have not taken into account, even though Mr. Andrews in his response said that it's exclusively the product of petitioner's knowledge and labor, which does not constitute, and then he goes on to say, does not constitute a marketable value of the business. Well, that does, Your Honor. That is the value of the business, is his brain and his marketing. And this is his sole support and has been for decades for his family of 9. So I think it's very relevant because it is a marital property for us to get a good valuation of what this business, how much this business is worth, so we can divide the marital estate. Because until we have a good valuation, I can't advise my client on, an equitable and just and fair settlement. So that's why I would ask the judge to allow us to have a business valuation. And I do have 2 possible persons that we could have appointed. And yes, I did ask that the business take on that because, and in my opinion, it's because they have skirted the value and not given a reasonable value. And because of that, I had to A, file the motion, and B, we're having to do the business valuation. So yes, I think the business should pay for the business valuation. And I ask that the judge grant my motion.
Okay.
And I just took up that one. I mean, I can do the switch.
You have 2 possible persons. For some reason, I thought this was an in-home business that they both worked together. And when they filed for divorce, or when the divorce got filed, because there were a lot of serious allegations at the time, that was a real problem. How are we going to continue this business when we both rely on the business, we both work in the business, and the business is a home business?
I understand that is your understanding, but my understanding, Your Honor, from my client is that she has not worked for the business. She was a stay-at-home mom. She homeschooled the kids. This was the business of Mr. Joseph, and it may be run out of his home, and it could be run out of anywhere. But it is not tied to my client in any way, shape, form, or fashion, other than it's been the main support for the family for the last couple of decades.
Okay.
And I can have her testify to that if you would like.
Okay. Do you have any recent research in Kansas or some close proximity? It seems like over time, goodwill has become kind of a thing of the past. And it used to be something that was tied to what might be considered a limited liability professional organization, or someone in a particular profession, like legal, medical, things of that nature. I actually had a case where in a horse business, I assessed some goodwill to the horse business because she had some unique talents. But I couldn't find much for support for the law, and I did a percentage calculation and some things that I had looked at from other jurisdictions, but I didn't see a lot of guidance in Kansas. So do you have some Kansas support for your proposition?
I do not for a business valuation. And that, to be quite honest, Judge, that is why I want an expert, because if goodwill is not going to be a part of evaluation, then okay, but I need to know I think the value of the business is much more than just the value of the computer equipment he has, that he values at $2,600.
Sometimes they take the average wage over, I think that's how I did it over 5 years and divided it, took a percentage. And anyway, all right, Mr. Andrews, your position.
Your Honor, my position is that my client's essentially a contractor. And I think he almost exclusively works for just one client, one customer, if you will, but he does computer repair. There's no real goodwill in the sense that he could market himself in some way that would allow him to have value other than just simply being able to do the job like any other computer technician is able to do the job. Our position isn't necessarily that we're opposed to a business valuation. It was that we are opposed. We are frustrated that how many years later, we're now asking for a business valuation in this case. So the delay is frustrating, but the biggest source of our objection is this idea that the business should pay for it. And there is no business separate from Mr. Joseph. So what they're really asking is for Mr. Joseph to pay for it. They had a business valuation that was, in my opinion, ridiculous. And that was essentially their position was we were being unreasonable by not agreeing to it. And we flat out said, if you think the business is worth that much, we will happily award you the business. You can have Joseph Tech, the name, any goodwill built from it, and you could just pay that value. But they're not willing to do that because they know there's no value to it. And so this is just meant to try to further harass and delay, incur additional fees for Mr. Joseph out of his pocket in an effort to essentially somehow, I don't know why, other than just spite, punishment, leverage, but there's no legitimate reason that somebody who works for themselves as a sole proprietor doing computer tech needs to have a full business valuation. This is something that he does out of his home on his computer. We listed the computer as a business asset, but there's nothing special about it. It's a computer. And if they want to pursue a business valuation, we're happy to make Mr. Joseph's happy to make himself and anything they need available to the valuator. But the idea is that they don't really want the business valuation. They want him to pay for it. And if they truly wanted it, they would get it themselves, but they don't want to because there's not really any purpose other than delay. That's our position. And I don't think that this is a situation where goodwill really applies. I mean, if this was something where Mr. Joseph was selling the business and entering into a non-compete clause, then there could be some generated goodwill that could have value, but that's not the situation here. They're just simply seeking to try to manufacture an asset out of thin air, and having Mr. Joseph incur additional expenses to prove that there's nothing here. And so we're asking the court, again, not necessarily to deny the business valuation if they truly want one, but to refuse the request for Mr. Joseph to pay for the business valuation that they're asking for, that we firmly believe is completely pointless, as there's no value to the business other than the limited value of the assets or equipment owned by the business.
Well, again, I've had a couple of
Tension crackles as a judge takes control fast. From the very first words, you can feel this isn't a routine case.
cases go to trial that were highly frustrating, truthfully, because no one wanted to pay. Well, one was the house that was kind of a ranch. And the other was an operation of a ranching business, neither of which were valued by any expert. But yet they didn't agree on the value of anything within the business. So it's like, if you're not, one person thought a horse was worth 50,000 and the other said it was worth 5. And so I was constantly in the trial going through trying to ascertain the value of things when I'm no expert and they weren't even close in terms of the value of if you just rely on assets within the business.
Well, and I guess our position, Your Honor, is that we can make it easy. We will award the business to Ms. Joseph at their value.
Your Honor, may I respond?
But that kind of proves their point, which is she could take the business but do nothing with it to generate income.
Right. That's my
There's
point,
no
is there's no
point
value to
There's
it.
Well,
no
okay,
end.
she can take the business, but she's not the business. She can't do anything with the business other than possibly sell it. But the worth is in Mr. Joseph's mind and his ability to work. And I do resent the fact that counsel has said that I'm doing this to delay and to harass. I am not. I'm doing this. so we can
No, I think
evaluation and to give
honestly,
this to you and say, here, judge, this is the value of what we're talking about.
I understand. I don't think he was suggesting that you're trying to delay and harass. He said they're just frustrated with it because this has been ongoing for a very long time. This is a very old case.
And I would like to get it over with, Your Honor, as well. And if the sticking point is paying for it, we would agree to split the cost of the valuation because it benefits both parties.
We
get
disagree
evaluation.
that it benefits us in any way to have a valuation that's going to prove what we've said, that there's no value to this. What she's essentially asking is to value Mr. Joseph as though he himself is the asset. She said that the value is him. He's not an asset. He's the person. If this is an issue based on income for support purposes, if that's what they're wanting to make the argument for, then there's some. There may be some validity there based on his earning capacity and past earning potential. But to assign a value to him for earning income is no different from saying that somebody who works and receives a salary should be valued for their salary because they bring in an income. That's not an asset to value. That's just income. This is not a marketable asset.
Has the parties applied for any loans at all in the last 5 or 10 years, using their business as collateral or an asset?
Your Honor, I think that the only, and I'll have to defer somewhat to Mr. Joseph if I misspeak, but I want to say that the only loan would have been like the small business loans that were through COVID that were available, but there wasn't any collateral put up as a result of that.
Well, that loan, they may have had to appraise or value their business.
I don't believe so, Your Honor.
That loan.
Not for the COVID loans. Based on my experience with the COVID loans, that they were not valuing businesses or anything like that. They were just essentially lending money.
Hang on just a minute. Like I said, I've had less and less cases where they're doing business evaluations because it must be expensive to do. So do you have some estimates on costs so I can take that into consideration?
Your Honor, I do not. I'm sorry, I failed to contact these two and see how much business valuation is. I can do so and let the court and of course, Mr. Andrews know what the cost would be.
And Your Honor, I was able to briefly find the statutory language on valuing professional goodwill, which is that professional goodwill is included in the definition of marital property to the extent that it is marketable for that particular professional.
So it does have value. And this is how he has made his living, supporting, I'm sorry, there's the word I was looking for, supporting his family of 9 for decades. And he may only have one client. I don't know, but certainly evaluation would help us. But
The word
So-
marketable implies it can be sold. And that's the whole point, is even, I believe, Ms. Adams concedes that this is not, any goodwill is not marketable. Otherwise, they would be accepting the asset to sell it, but they know that it's not marketable, which is why they don't want to accept the asset.
Okay, hang on. If you want to look at AI, it talks about differentiating personal versus enterprise goodwill. Personal goodwill, this is the intangible value tied to an individual's skills, reputation, and relationships within the business. Enterprise goodwill, this represents the value inherent in the business itself, brand, customer base, location, and is independent of the individual owner. The distinction is crucial. I'm not suggesting this is Kansas law, but the distinction is crucial as courts often treat personal goodwill as non-marital property, not subject to division, while enterprise goodwill is typically considered marital property. And then they talk about the valuation methods, which can be market approach, compares similar businesses being sold, to the asset, which calculates the value based on the business total assets, both tangible and intangible, minus its liabilities. And then an income.
Mom sets the tone, but her words carry sharp edges. She's framing herself as the victim, but subtle digs don't go unnoticed.
Approach, which is what I used in that ranching situation that I was referring to, that estimates future income and converts it to a present value estimate. So, okay, well, I think first off, there needs to be an idea of what kind of costs we're talking about, 5,000 or 50,000. I mean, 500 or 5,000. I mean, I think that if you've got a couple people in mind, then I think that we ought to have an idea of generally a ballpark cost.
okay.
We don't have right now.
No, and I apologize, Your Honor, for
Then
that.
I think I need you both to do a written letter memorandum, so it can be a page or two. When I say that, I don't need a full brief. I just need, hey, I've looked at the law, here's a few cases. This is what I think you should rule. And I invite you to look outside of Kansas if there are no Kansas cases. Or some kind of treatise or something that you want to cite.
Okay,
And so I'd like you both to submit within 14 days that memorandum. And then if you want to reply to one or the other, you're free to 7 days later, which means that I can take the matter up in 21 days, which should allow you time to get some cost
oh, most definitely, Your Honor,
for me.
most definitely.
And then I'll rule.
Okay,
Meanwhile, is the motion to compel and attorney's fees, et cetera, something that you want to address today or hold off until?
we can address it today.
Okay,
It is simply, I have asked, or prior counsel and myself have asked several times for certain things. And from the beginning on several of these, the response was, well, that's in the hands of the respondent. And I'm asking, or we, like, one of them is, I believe it's, well, debts. And we asked for, any debts of the petitioner, and they said that's the respondent has all that information. Well, that doesn't tell me anything. If there are no debts, then please tell me that.
That's
But
not
they-
accurate. It was respondent's debts that we said were in her possession.
No, it says whether you have any outstanding debts or obligations, including mortgages, conditional sales, contract obligations, or promissory notes. That's what number 40 says.
Yes, but we provided that information and said that any debts in her name are in her possession, and that's what was objected to. We provided all of the debts that were in my client's name.
I believe the response, hold on, I have it. Oh, I had it. Believe the response was, you gave one extra Capital One credit card or something like that. And I'm sorry, I had that Capital One credit card. And then nothing else, but I believe the additional of response was the rest are in the hands of the respondent. He didn't say that was all of the petitioners. And if it's all the petitioners, that's all I'm asking for. I'm not asking for anything outlandish. And the same kind of response happened on interrogatory number 31, where I saw information on all building structures and other improvements to the real estate commonly known. And this is the marital house. And he said, all that's in the hands of the respondent. Well, she lives in the house right now, but the petitioner has been responsible for all the improvements, et cetera, on the house. And shifting the burden back to the respondent for something she doesn't have the knowledge of, it is wholly not answering my question, that's for sure. And then the third thing I asked for were emails for the last 12, or emails, text, communications for the last 12 months. Oh, I know, I'm looking at your response, which is why I'm not finding what I'm looking for. Apologize. Anyway, the third thing I was asking for were these communications between the two regarding marital or non-marital property and finances. And every response is documents are in the possession of the respondent. And I'm asking, there are things I can glean from asking for these things that are not maybe readily apparent to opposing counsel and the opposing party. But in my 35 years of practicing law, I can find, if I can get an answer besides an evasive answer, I can learn a lot of things. I can learn what has been kept, what hasn't been kept, what is important to this person, what is not important to this person. So yes, well, I can get the real-time text and communications from my client. I can't get what is important to the petitioner without asking him. And that's why I'm asking. I'm asking to see what he has. And if there's something different than what my client has, I have a right to that. So I don't think it's an unreasonable burden, and I don't think it's an unreasonable request. It is certainly, and it's about the financial. I'm not asking for all the communications, but about the financial information. And that is certainly relevant because that's where we are. That's the crux of this whole argument on why this case hasn't been resolved, is because we can't resolve the value of the marital property. And I'm just trying to do that. So.
All right, Mr. Andrews.
Your Honor, there was three mentioned. The first is information on the building structures and other improvements to the real estate at 5682 Southwest 150th. As Ms. Adams stated, this is the residence in which her client has been living. My client's not been on that property since approximately October 5th, 2023. So any information he may have about those building structures and other improvements would be completely outdated. He has no real idea on what has been improved since then, what the condition of those structures are. So this is outdated information that they're seeking, that he'd be going off of memory, that she has better access to and more current information to through her client. Further, there was an actual appraisal of this real estate that was done that has all of that information in it, which she has. So there's no reason why, there's no legitimate basis for requesting this information and insisting on this information be provided for my client when it would be.
Dad's calm rebuttal hits harder than any outburst. Every fact he drops chips away at Mom's carefully built story.
Questionable because of how long it's been since he's been out there, outdated as compared to the information that her client has, and there's better source of that through the appraisal that she has in her possession. And I would just stop and go back and say for a second that we are actually not just objecting to this, but we're seeking a protective order from the court, specifically ordering them to stop requesting this information based on KSA 60-226B1. And we are alleging that the insistence that he provide information on the real estate that her client is living in after already having access to the appraisal. And again, this isn't information on documents that only my client has access to. This is information on what is actually the physical condition and physically present at the property that she's living in that my client does not have access to, that this is nothing more than an annoyance, undue burden, and unnecessary expense subject to a protective order. With regard to the debts, I have repeatedly told Ms. Joseph's attorney, I think it was probably her prior attorney with the same firm, that the remaining debts are all in her client's, in Ms. Joseph's name alone. My client doesn't have any access to that information. And when I said that, the response from Mr. Britt was that my client likely knows the answer or can provide a response to the best of his ability, even though he, what I perceived, acknowledged that these were not debts in my client's name. My client did not have any access to the information on these debts. These were all debts that were in his client's name, and she was the only one who had access to it. And so he was effectively pushing for a response that would have been nothing more than a guess, or would have been the limited information that we received in our discovery requests about these debts, and is nothing more than an effort to harass Mr. Joseph, and constitutes an annoyance, undue burden, and unnecessary expense. And again, this is not something that was just conveyed to their office once. Multiple times I have said, these are her debts. We don't have any information on them. With regard to the blanket request for any and all communications from my client to Ms. Joseph, I don't agree with the characterization that this could provide relevant information that would be somehow different from the information she would get from her client, who has actual possession of this, of any letters or notes that were provided by my client to her, text messages and other correspondence that go back for an entire year between parties who have minor children together. If there's anything relevant, she would have access to it. What instead they're asking is that my client bear the time and expense of combing through all of this information and providing it to them so that they don't have to. Again, this is just an attempt to cause Mr. Joseph to expend additional time and money in this matter. It's an annoyance, an undue burden, unnecessary expense, because again, they have access to all of this information through Ms. Joseph. They are better situated to determine what is or is not relevant to their theory of the case. And by asking Mr. Joseph to go and do all of this and asking him to spend not only his own personal time, but also to incur the legal fees of going through and making all of this information ready, is just an attempt to cause him this unnecessary delay, or not delay, but unnecessary expense as well as a delay. And I would go back and say, Your Honor, that part of our frustration as well is that these discovery responses were submitted on February 28th of this year. And it was not until May 2nd that Mr. Britt sent a letter stating what he believed to be the alleged deficiencies in the discovery responses. Now, we concede there were some issues with the original responses. There were some oversights that were immediately corrected. I believe May 2nd is when the letter was sent. May 13th, we provided the unverified supplemental responses to those answers. And then May 19th, I was able to provide the verified supplemental responses to the requests. So
Yeah, I recall there's been a little bit of teeth pulling with your client with things. I do acknowledge though in some, again, I don't want to reference everybody else's divorces, but I do acknowledge that sometimes digitally it gets a little problematic to recreate things or reconstruct things. But when I look at page 4 of her motion, on interrogatory number 31, what I see her asking is, you know, in his supplemental responses, he refers, when asked to describe building structure, other improvement of the property owned by him, his response is, this is in the hands of your client, which is what you've just argued, which I get.
And Your Honor,
hang on.
Okay.
She's been there since September 26th of 23, but what I think she's asking is for purposes of trial for you to marry
The evidence drop that flips the whole hearing. One look at the judge's face says this changes everything.
yourself to a particular answer. So what I would interpret is we have this valuation of the residence. This is what it's been appraised at. I want to make sure your client doesn't come in and say, you know, I built a special chicken coop, you know, in the North 40 that wasn't on the appraisal, that is an improvement that is on that property that should be considered. So to me, what they're asking is there they want to make sure there's nothing that your client's going to claim that is of special value on that property that isn't covered by the appraisal.
And Your Honor, I would say that the original response was pretty blanket as to this information is in their possession. We then supplemented that by answering each of the subsections, and which includes a request for the fair market value. We conceded in there that the fair market value is $250,000 in our responses. So we've married ourselves, if you will, to the value of the property. We've married ourselves to the information as far as purchase price, who has the mortgage, attaching the deeds, no objection to the appraisal. That was a joint appraisal. I mean, that wasn't asked in here as far as do you object to the appraisal, but I could say that on the record right now, we do not.
Why would you then be uncomfortable with on interrogatory number 31 saying none other than those things identified in the appraisal?
Because, Your Honor, I think that the concern that I have is that my client is verifying under penalty of perjury, under oath, that this is accurate. My client's not been on that property in over a year. To say that this is exactly what is out there when he doesn't know is problematic. Because now he has put himself out there as essentially trying to describe all of the outbuildings, everything, any improvements that have been made, and stating under oath that it's true when he doesn't have any idea if it's true or not.
All right, let me say this. I asked for a pretrial conference and a pretrial conference order and get this dang thing scheduled for trial. The response was it's not ready for pretrial conference. If we have a pretrial conference order and you stipulate as to the appraisal value and the agreed upon value of the house, and there are certain things that you agree to factually in that order, that's going to govern everything that happens during the trial. There aren't going to be any surprises, right?
Yes, I agree with that, Your Honor.
I'm looking at 40 here. Information is non-responsive. He was a vague and deflecting mortgages, and then on remaining debts. Remaining debts are in respondent's possession. He listed page 2 of the mortgages, and then stated.
And Your Honor, we would concede that there was one credit card that I was under the, it was my understanding that that was in Ms. Joseph's name. It was not in her name. She had taken it out in my client's name. He didn't know about it until later. So, but technically, since it was in my client's name, it was not necessarily something that Ms. Joseph would have we don't know for sure she would have had access to it. So that's why in the supplemental, we had included the Capital One bank credit card. And you know, as much information as we could, which wasn't much because again, it was incurred by fraud using a forged signature. But what we have been able to at least provide, we did.
Okay. Well, again, I know that, you know, this is kind of a fine tooth comb of making sure, are there any liens against the house that she may not be aware of, or any other claimed I don't want to use word infringements on the property, but is there anything out there that he knows about that we may not know about that may encumber the property?
Not that my client knows about.
Your Honor, I would also say that in his May 2nd settlement offer letter, I believe it's May 2nd. That's what I wrote in my motion. I'm trying to find the actual letter. Mr. Andrews listed other debts, and that was the first I had seen those. And that was what I was trying to get information on, where
But
he
those
got.
are all debts that are only in her client's name.
Well, but you didn't tell me that.
But your client could have, I would have thought.
Your Honor, he's responsible for answering the questions. I mean, I don't get why I've had to ask 5 times for the same thing. And if the answer is there are no more debts that I'm aware of, then there are no more debts that I'm aware of. I'm just asking for an answer instead of reflecting it back on me.
That was never the question. The question was, why are you not providing us information on my client's debts? And our response was, because we don't have that information. They're in your client's possession.
And that is.
And don't you think that on a pretrial conference order, it's going to have listed for me the agreed upon liabilities at issue?
Your Honor, you are. If your pretrial order has that, then great. I am, like I said, new to your court. I'm new to Kansas. I've been in Texas for 35 years.
Okay.
And I did not do family law in Texas. So I'm just, I'm following up on, yes, Mr. Britt's discovery request.
Yeah.
And
they're admittedly, they've admitted there's been difficulty getting that done quickly and everything covered. And I don't know, I'm sure everybody's got their own belief as to the reason for all of that. But I think what I need you to both do is a pretrial questionnaire. And then you're marrying I don't want to use the marrying again, but you're committing, I think, to what the issues are, what the debts are, what, so that you're on the same page. And then, because I think we have, I can always sanction on an issue of non-compliance with discovery, but I think we're past discovery deadline, and I would rather see it in a pretrial conference questionnaire and final order. And then if you get to trial,
The judge turns up the heat, pressing for truth without mercy. Every question cuts deeper, leaving no space for slippery answers.
and there's something that comes up or is requested, or that is brought up that isn't either in the pretrial order or, just as importantly, was basically non-compliance with the discovery order, you can bring it to the court's attention at that time. And then the court can look at, did this fall under your motion to compel? And your client has now been prejudiced by it being brought to bear at trial. And is it something that's been or should have been in the pretrial order? So
Okay.
they make a claim that there is this fund out there that was supposed to be satisfied, that wasn't satisfied for $7,500 or whatever the case may be, and it's not in their pretrial order, and they didn't respond to it in discovery, they're not going to get a claimant.
Okay. That's
As
fair enough, Your Honor.
Or anything that she should pay half of or whatever else.
Okay.
So I think since we're at you are at a disadvantage coming in later on the case. And this has been a long drawn out case for a lot of reasons, besides the fact they're a family of 9, like you mentioned. But I think that this could go on and to the point of splitting hairs. I'm not suggesting that's what's happening right at this moment, and I think that to move past that, we need to get committed to a questionnaire and an order and get this case scheduled for trial.
Okay. And do
And
you
the
have,
only thing hanging is the ruling on the business
right.
appraisal.
Do you have a pretrial questionnaire that you prefer? Is it on the website? Again, this is, I don't mean to show myself as being ignorant.
No.
Just want to follow your rules. If not, I mean, I
Well,
think I can find
it started with the civil attorneys and mostly civil cases. That's just been, I don't know that's been modified much for domestic in particular. But I've got a few good ones, sample ones that I will get you. Probably not this week because my AA's out with the sick child, but I will get it to you next week.
Absolutely. I think I have a few things to do on my plate.
Okay.
When is the pretrial questionnaire due, Your Honor?
Mr. Andrews, I'm not sure that we can do that. I can ask you to do that before the 21-day ruling. Because
I agree, Your Honor.
Will need to be included. So let me give you a timeline after we get past this
Okay.
goodwill, business appraisal issue. And let me make sure I understand. You want a business appraisal that includes goodwill if the person doing the appraisal believes there's also goodwill associated with it. But even if there's no determination, there's no goodwill, you still want a business appraisal.
Yes, because I think, and I could be wrong. I mean, I could very well be wrong, but I think that there's a value to the business other than what he has been putting down on his taxes, et cetera. I have reason to believe that he has not been doing so well in his business, so he wouldn't have to pay child support as much and spousal support. I'm just saying I have reason to believe. I don't have anything concrete. And I'm trying to see if the business is worth more than what we're seeing on the financials. And I think it is. If that's goodwill, great. If that's something else, if it's, I don't know that I would term it all goodwill, but I think that's the reason why I'm yapping, is because I don't know that I would term everything goodwill, because I think there's more to it, but I could be wrong. And I
Well,
just,
all right. Okay, so 21 days, Amy, let's see. Let's just go with the first.
okay.
So what do I have on August the 22nd?
That is a Friday, so it is your, and it's docket week.
What about Monday, the 25th?
You have a prelim in person from 9 to noon, and then you're open that afternoon. And
Okay,
then we have a jury trial starting on the 26th.
okay. And how does your calendars look on August the 25th in the afternoon?
I'm available, Your Honor.
I'm available, Your Honor.
Okay, so what time works best for both of you?
You just name the time. I'm free for you.
Yeah, I have
Oh,
that entire day available.
Okay, well, let's do a 2 o'clock.
Okay.
All right, we'll see you then.
Okay. Thank you, Your Honor.
And I'm so sorry, Your Honor. I want to make sure. So 2 o'clock is going to be, is that August 25th? Is that the pretrial conference?
No, that's gonna be when I rule about the
Okay.
business
Perfect.
valuation and goodwill and that whole bit. And then that's when I'll have a sample questionnaire ready. But that's when I'll rule on when your questionnaires and or order will be due.
Got it.
Perfect. Thank you, Your
Okay.
Honor.
Thank
All
you,
right.
Your Honor.
We are adjourned.
Thank you.
The verdict lands hard, and truth wins the day in this courtroom. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.